Okay. All right. Well, let's see here. There was something else that we talked about while we're talking about developments and thinking about this whole area of estate and gift. And as I mentioned to our viewers, again, we mostly talk about things from a California standpoint, but there are other states. And now California, there is no estate tax currently because the California's tax was based on the state tax credit, which is
the pickup tax.
The pickup tax, which has been sort of eliminated temporarily. It may come back after 2012. We don't know. And other states, though, they actually do have state estate tax or state inheritance tax. And so there may be some special planning that people need to think about related to that, and maybe you can comment on that.
This is not just about same-sex couples. This is about everyone. If you live in California all your life and all your property is California property, you may have no need to know the laws of other states. But there are quite a few states that have their own estate tax, and we say it's decoupled from the federal estate tax. So, for example, the state of New Jersey has an exemption amount. It's not $5 million. It's only $675,000. It was tied to the federal exemption, but that was a long time ago when the federal exemption was $675. New York has a $1 million exemption. The state of Washington only has a $2 million exemption. Oregon, Illinois. In fact, if you think about it, a lot of these states are states that recognize same-sex couples. They recognize them as registered domestic partners, civil unions, as in Illinois and New Jersey, or as married in New York recently. So for couples who may be subject to an estate tax there, you don't have to live in New York to be subject to an estate tax. You could have property there.
Right.
People who represent any such clients need to think about doing some marital deduction planning if the estates in those states are over their lower exemption level. And it's a very complicated, there are conflicts of laws, questions, there's trying to know what the law of each individual state is and then plan for it.
All right. Now, one really big item, as you said, is this marital deduction.
Yes.
And so it's clear that outright transfers qualify, but we've also evolved in our federal tax law this concept of what we call a qualified terminable interest trust. It's basically a trust that we can set up for the spouse. They get all the income during their lifetime. They can only get the benefits themselves during the lifetime. And then, but the advantage is that the decedent, the person who leaves them the property, can control where it ultimately goes.
Yeah, there are mixed feelings about this. You know, sometimes think that it is the living who should control the devolution of the property. But this was a trade-off in the early 1980s when they were creating the unlimited marital deduction as well.
Right.
Gee, I could give everything to my surviving spouse outright and escape tax, but you know, I really want to be able to say where some of that property goes. I don't want her to get remarried and give it to her new husband. I mean, I earned it, I want it to go to my children.
Yes.
So normally terminable interests don't qualify for the marital deduction. Could give her a life estate followed by a remainder that would not qualify. But if I put it in trust and I make it a qualified terminal interest property trust, it will qualify. Got to be sure she gets all the income, nobody else can have anything during her lifetime, but I get to say where it goes at her death, and we'll treat it as though she gets it outright. I'll get the marital deduction, the person who dies first will get the marital deduction, and at her death it will be included in her estate as though she owned it. That's the trade-off, and it makes sense because you are deferring the tax until the death of the second spouse. Deferral of tax, of course, is always good. And so that works. For same-sex couples, this is an important concept, especially in, well, both at the federal and the state level. At the federal level, if I wasn't sure whether DOMA was going to be gone, and I had a $10 million estate and wanted to do some marital deduction planning. I don't have a $10 million estate, let's just make that clear.
Okay.
But if I had one, I'd want to take my $5 million exemption. I could leave that outright or in a bypass trust, do whatever I want to with that. But then the other $5 million, I'd want to put it in a Q-tip. I'd want it not to get taxed on my same-sex spouse's death. I want our nieces and nephews to get as much as they can rather than the federal government. And I could claim it's a marital deduction if I die before DOMA falls. My estate could claim it. and we would fight with the IRS. We might go to court over that. If I lost, at least I wouldn't have given everything outright, and it would serve as a bypass trust at the death of the second spouse in this case. So there are certain ways that Q-tip planning is very helpful for same-sex couples. And it's helpful in these states where you've got a smaller estate tax exemption. So if I'm in New Jersey, I might want to use a New Jersey Q-tip for any extra funds over the 675, especially if it ends up exceeding $5 million.
Now, in California, well, excuse me, on the federal, from the federal level, you have to make an election on the federal estate tax return in order to be a Q-tip.
Yes.
So now, in those states, well, first of all, the federal government doesn't recognize Q-tips. So now, how are the how are they going to make that election in those other states?
Well, the states will recognize it. Every state that has that recognizes same-sex unions, whether they're marriages or spousal equivalents, authorizes that couple to file a state-only Q-tip. Okay. Now, for some of them, it means filing a pro forma federal return. It's just like the income tax. If you're going to file a joint return at the state level, you fill out a federal tax return as though you were able to file it jointly, and then we figure the state tax off of that. So in the estate tax, it would be the same thing. You would file a pro forma federal estate tax, and you wouldn't file it with the feds, you file it with the states. And they will recognize your Q-tip election.
So you'll make your election still on the form, but you'll be filing with the state and not with the federal government. Yes. And then you'll be filing a different form with the federal government if you're subject to federal tax.
Provided you're over $5 million right now.
Right.
Yes.
Yes. Okay. Okay. So how about the double step up? This is another big issue. Yes. So for community property, as California here where we have community property, one of the things that we tell people for estate planning that's very important for them to be aware of is like difference between joint tenancy property and community property. That community property is sort of a magic asset in a way that if you're married and you're not same-sex couple, then both parts of the property are adjusted to the fair market value at death as far as the cost that you use on your tax return that we call the tax basis when you sell that property. Yeah,
we call that double step up in basis. Now, of course, these days it might be step down in basis.
Yeah, maybe for
but we think of it as an attractive thing, because normally when someone dies, let's say I own Blackacre, 100%, I die, it gets taxed in my estate, and the feds give a total step up in basis. If I bought it for 10 and now it's worth 100, it will be taxed at 100 and the basis will be 100. If I own that jointly with someone else, only the portion that I own, the 50%, let's say, that I own, goes into my taxable estate and gets the step up. Community property is owned 50-50. Logically, only half of the community property ought to get the step up, the half that was owned by the decedent and got into his or her estate for tax purposes. So this is a pure boondoggle. I mean, it's a benefit for, it's been around forever. It's not going away anytime soon. Yeah. And so the surviving spouse's half gets the step up as well. Now that's the federal law. It's in section 1014, and it uses the word spouse.
Yes.
So because of DOMA, same-sex couples cannot take advantage of that rule at the federal level, but because they're recognized as spouses or spousal equivalents at the state level, you do get the double step up in basis for California income tax purposes. Now, I cannot provide you a site for that. I thought that it would be in the California instructions from the FTB, the Franchise Tax Board, about community property, but there was no reference to it. So I had a long email exchange with some of my good friends in the Franchise Tax Board yesterday, and it turns out there is no public written position that says that. But their internal records, and she sent me one of the internal records, says that yes, as of 2005, any decedent in a same-sex relationship who dies after January 1, 2005, that's when the community property regime took effect for same-sex couples, will be entitled to the double step-up in basis. What I didn't know, because she sent me the chart that they have internally, is that you didn't get the double step-up in basis at the state level, even for opposite-sex married couples, until the mid-1980s. So California was not following federal law, and then it started following federal law about 1986.
Yeah. Well, I mean, I've been in public accounting for a long time, and as far as I recall, I've probably been working heavily in the estate area since 1978, and I think we have been using the double step-up even for California.
Well, their chart says otherwise, so that's interesting.
That is interesting. So again, well, part of this is people need to check into their own state tax laws related to this. And again, community property isn't everywhere, but that's why some states decided to actually adopt community property. And so it's something to be aware of related to this, but again, you have a different treatment for federal and California. I remember one other thing I wanted to mention related to this. From a practical standpoint, it's a big convenience to have a fresh start and basis. When somebody passes away.
Record keeping is a problem if you have to use historical basis.
Yeah, we've all been worried about carryover basis and so forth, but you know, because of the repeal of the estate tax law in 2010, if people elected to do that, but only a few have, and so we're all scrambling. You know, where are we going to find these records? Not everybody has them. It can be very difficult, and so it sort of eliminates that headache.
That's right. Okay,
well, we're really about out of time, believe it or not. Things have gone awfully fast, but maybe are there some final words of wisdom or thoughts that you have, something, maybe a final idea that you wanted to cover?
Well, just that I think everybody who works with same-sex couples needs to be aware, most people are aware that DOMA exists, but given the challenges and given the times and given the support for same-sex marriage across the country, be aware that DOMA is not going to stay with us. And it is so difficult to get clients to come back into your office to do estate planning with them, that if you have clients now you're doing estate plans for, do some contingent tax planning, assuming that DOMA will be gone by the time one of those clients dies. I call it contingent marital deduction planning. If you've got a taxable estate, I really think you need to be doing that.
Yeah, so that is something. So you can sort of build into your document, if such and such, then such and such.
And some people are doing that by naming trust protectors. That's a big recent phenomenon. If you put stuff in trust in the will, name someone who's a trust protector who can make certain changes to the trust after death, after the client is dead and can't do it. If someone is available that's trustworthy who can make the changes necessary to qualify for the kind of tax planning you need.
Yeah. So this is somebody that you really do trust.
And is willing to take the responsibility. That's the other hard part.
And usually it won't be a beneficiary, and won't be the trustee. It's going to be sort of an independent person. And you're giving them this power to basically rewrite your will or trust.
With a lot of guidance.
Yeah, okay. All right, folks. Well, you know, I think you can appreciate that, that this is a difficult area. There's a lot of unanswered questions. But again, estate planning is essential. You do need to get together with an attorney and try to work through the problems the best that you can. And really, it's essential. So with that, I think I'll just say we hope that you'll consider these ideas, and we'll see you next time on Financial Insider Weekly.